defense?
Sarah Brandon with the Office of Capital and Forensic Writs on behalf of Otis McKane.
John D. Matthey with the Office of Capital and Forensic Writs on behalf of Otis McKane.
And Otis Tyrone McKane is present in the courtroom, is that right?
Yes.
All right. So this is a writ hearing, is that correct?
Yes.
All right, you can proceed.
Your Honor, we have just a couple quick housekeeping matters. One is just so everyone can plan for today, the way our witnesses schedule and lineup shook out is we do expect today to be a little bit shorter. We don't expect needing the full day. Just wanted to kind of give everyone a heads up on that. And we would like to start by moving in some applicants' exhibits, and then from there ask to do a brief opening and then move to putting on our witnesses for today.
Okay. Now we do have a full trial docket, right? So we do have lots of cases that we're dealing with beyond this one. We have set aside a particular period of time to hear this case. I would rather utilize every day that we have available for this as much as we can.
I understand, Your Honor.
So I
yes.
prefer to go today till 5 if that's possible.
We have experts flying in today. We can see when they come in, but we do expect to utilize the full time for tomorrow and Monday and Tuesday, all the time set aside. The rest we do expect to be used.
Okay, and hopefully today as well.
We'll do our best.
Thank you. State?
Judge, we have a couple of housekeeping matters to take up as well. But before we get to that, I don't know if you want to cover the exhibits that they mentioned just a moment ago to kind of keep it in order there.
Okay, let's go ahead and do that then. Defense?
Your Honor, as part of our habeas application, we had included 108 exhibits, and we would first move to admit applicants' exhibits 108 into the writ record.
Judge, the state has had the opportunity to review that exhibit, and we have no objection.
All right, it's admitted?
And Your Honor, may I approach?
Yes.
Your Honor, this is applicants' exhibits 109, 110, 111, 112, 113, 114, 115. These are new exhibits that we would like to move in, so applicant moves to introduce applicants exhibit 109 through 115.
And Judge, we have copies of those exhibits here. We've had the opportunity to review those exhibits, and we have no objection.
All right, those are admitted.
Your Honor, I expect there are a couple of times we may need to approach a witness. Would you like us to ask permission to approach witnesses each time?
Yes, just to make sure the record is complete.
That's all I have.
And Judge, just a couple of things from our end, and this is just to make sure we explicitly state it on the record. We'd like the court to take judicial notice of the clerk's file from the original proceeding and the clerk's file as it exists for the writ proceeding.
All right, the court takes judicial notice of all of that.
We'd also like the court to take judicial notice of the record from the time of the original proceeding as well.
Court takes judicial notice of the entire record.
And finally, Judge, at this time, we'd like to invoke the rule for any witnesses that are currently in the courtroom to be instructed that the rule has been invoked.
All right, what I'll do, the rule's been invoked, so what I'll do is I'll instruct both sides to make sure that your witnesses understand the rule and explain to them and that they comply with it accordingly.
Thank you, Judge.
All right.
We've all had the experience of feeling misinterpreted or misunderstood. Perhaps something we said was taken out of context, or someone didn't take the time to get to know you. It's an awful feeling. When someone thinks they know something about you, something you did or said, and then has a bad impression or judgment about you, it's painful. When someone has a judgment about you that's wrong, and that isn't representative of who you really are. Imagine that feeling when the stakes are at their highest. A death penalty case where defense lawyers are tasked with telling jurors the story of their client's life, and jurors are tasked with making one of the most difficult decisions in theirs. Our post-conviction team, including myself, have had the honor and pleasure of getting to know Otis McKane, who he is, his life and his experiences, his family, But the jury at his capital trial did not, and that is because his trial counsel did not. Mr. McKane's trial team had a legal and ethical obligation to undertake as full investigation as possible into their client's life. They were required to talk to people across his entire life, collect as many records as possible with their client's name on it, investigate his family's history, retain experts tailored to help tell their client's story, and present a full portrayal of Mr. McKane's life. They did not. With little investigation into their client's life, the result was a penalty phase riddled with errors and misrepresentations. These falsehoods replaced the facts the jury should have heard in this case. In this hearing, the court will be reminded of the story that was told at trial. The prosecution, for their part, told the jury that the offense was premeditated and that Mr. McKane is a diagnosable psychopath. There were two main ways the prosecution accomplished this. One, by completely misinterpreting the contents of Mr. McKane's cell phone. And two, by presenting the testimony of a psychiatrist who was willing to lend his purported credibility as an expert to label Mr. McKane with the most prejudicial names someone can be called at their death-penalty trial: antisocial, sociopath, psychopath. This court will hear evidence during this hearing that both of these were significantly flawed and misleading, but trial counsel challenged none of it. Regarding the cell phone, this court will hear that the prosecution wildly misunderstood the contents of the cell phone. Our phones have a mind of their own these days. They are constantly capturing images and data we may never see or even know about. That happened in this case. The vast majority of the contents of the prosecution gathered from Mr. McKane's phone and presented at his trial was generated and stored without his knowledge. The best example is this: an image of an officer slain in California near the time of this incident. At trial, the prosecution portrayed this as a Google search and as evidence of Mr. McKane's premeditation and hatred for cops, something that would carry great weight with the jurors sitting in this type of case. But that evidence presented was wrong. Our phones have all kinds of applications, and if these are opened and even running in the background, they are constantly capturing images without our knowledge. And within seconds of Mr. McKane's phone capturing the image of that officer, the open application on his phone that was running in the background also captured tons of irrelevant other images, such as a golfer, a football player, and logos of Pfizer and Mobil. The application ultimately captured hundreds of images and saved them to Mr. McKane's phone with no intention on his part. The prosecution also insinuated to the jury Mr. McKane saved dozens of photos of guns on his phone, intentionally researched a gun show that was happening in Texas, and purposely collected and saved images of Detective Marconi. But this court will hear that the state's analysis of this evidence was also deeply flawed and severely overstated the significance of the cell phone data to the jury, but was still used to convince them to sentence him to death. Now, the psychiatrist the state presented, Dr. Michael Aranda, there is no other way to say this than point blank that that psychiatrist's opinion was totally unmoored from any of the scientific and ethical principles that guide good psychiatric opinions. And because the state fed Dr. Aranda its theories about the cell phone evidence, the data he based his opinion on was also flawed. With the misrepresentations of the cell phone evidence and Dr. Aranda's opinion in hand, the jury was told a story about a person who fit a stereotype that the state knew the jury would fear. They told the jury that Mr. McKane has the same diagnosis as Charles Manson. By the way, Dr. Aranda's opinion was also based on his willingness to tell the jury he knew all about Mr. McKane, a man he never met. There was another psychiatrist the state hired, however, one the jury never heard from, one who did take the time to interview Mr. McKane personally, who used a methodology principled and based on science. And while the jury didn't get to hear that testimony, this court will today. That expert's name is Dr. Fabian. And this court will hear from Dr. Fabian that he spent several hours with Mr. McKane, asked him all kinds of open-ended questions, dug into Mr. McKane's upbringing, his family, and even his criminal history. Dr. Fabian would tell this court that based on his decades of experiences treating individuals with personality disorders, simply put, Mr. McKane doesn't have antisocial personality disorder. This court will also hear from an expert in risk assessments of personality disorders. Dr. John Edens has dedicated his life's work to ensuring that mental health experts rely upon sound methodology when making predictions about human behavior. His research into psychopathy and the prejudicial effects of that label on jurors will reveal to this court that when that label was used in this case, Mr. McKane's fate was signed, sealed, and delivered. This expert will also tell the court that the prosecution psychiatrist went rogue. There isn't research, peer-reviewed articles, or science to back up his opinions, even though he told the jury there was. The problem with Dr. Rainbow's testimony is that jurors, whether they intend to or not, tend to fall back on stereotypes of what they imagine serial killers and psychopaths are. And they use that in deciding the special issues in death penalty cases, the future danger issue and the mitigation issue. And prosecutors know this about jurors in death penalty cases, and that's why they presented the testimony of Dr. Rambula, someone willing to give them the label they wanted without even ever asking to meet Mr. McKane. In all of this, the flawed cell phone testimony and the flawed psychiatric testimony went completely unchallenged by trial counsel. Even though the state disclosed the cell phone discovery years in advance of trial, it is remarkable to stand here and say that the stated reason trial counsel gave for not looking at the cell phone data in this case was because they couldn't open it. They told the court that because they couldn't open it, they assumed the state couldn't open it, even though the state laid out for them exactly in their 404B notice what they intended to do with the cell phone contents. Based on the state's use of the cell phone evidence at trial, the mistake was obviously disastrous. This court will hear evidence at this hearing that counsel had every opportunity to find a way to open the discovery, work with an expert to understand how certain contents got on Mr. McKane's phone, and be prepared to challenge the admissibility or at least the weight of it. And by not investigating their client's life, they left themselves with little to share with the jury about him, the things he cared about, his dreams, the things he struggled with, and how eventually he grappled with mental health issues no one saw coming. By the end of this hearing, this court will hear evidence that a full, humanizing portrayal of Mr. McKane's life story and struggles with mental illness were not told at trial. How did this happen? Because trial counsel did not spend enough time with witnesses or their client. This court will hear that a proper mitigation investigation requires meeting witnesses in person in a place they're comfortable with. You ask them open-ended questions. There's a saying, you have to meet witnesses where they are. That means don't judge them. Don't make demands of them. Be patient, build trust, ask them their stories and details of what they can offer to learn about your client's life. The mitigation investigation must also be done immediately upon trial counsel's appointment, so these critical witnesses are contacted right away and trust can be established with the defense team. I want to assure this court that clients with mental health issues and family witnesses that struggle to open up, those are normal. Those are expected and anticipated in every capital case, and they are rarely insurmountable. But the things capital defense teams are trained to do to build relationships with clients and important witnesses was not done in this case. The court will hear evidence that in the first 6 months of trial counsel's appointment, no mitigation investigation was done. They didn't even hire a mitigation specialist. And when the team finally hired one 6 months into their representation of Mr. McKane, she spent the next 3 years doing nothing even close to resembling what a mitigation investigation should look like. Hardly any witnesses were spoken with, hardly any records collected. There are no memos or research to reveal substantive work product that should represent 3.5 years of work. The team replaced that first mitigation specialist with a second one, Dr. Wanda Lynn Taylor, and the court will hear from Dr. Taylor herself that even her mitigation investigation hardly got off the ground. One of those reasons, of course, is the pandemic in March 2020 that we all know lasted much longer than anticipated. Witnesses were understandably reticent to talk during that time. But Dr. Taylor kept in touch with those closest to Mr. McKane and managed to build good relationships with the family, finally. They liked her, they trusted her, they shared things with her. But the trial team was at best disinterested in the mitigation investigation she tried to conduct. In fact, this court will hear that in this case, Mr. McKane's trial lawyers didn't even inform the mitigation specialist when trial was set. She had no idea when her deadlines were and no one checking in on the status of her mitigation investigation. This court will hear the circumstances of Dr. Taylor leaving the team and how the trial team asked a fact investigator's wife to step in. And that between May and September, and the months that should have been the last exhaustive effort to mine all evidence possible about their client's life, Carol Parker worked 56 hours. Most of that included running witness locates for witnesses she would never talk to and attending trial. And so what happened? In the penalty phase, trial counsel's inadequate investigation resulted in them unable to challenge the state's narrative, but also telling their own half-truths. You see, trial counsel chose an easy road from the outset of this case instead of doing meaningful investigation. Like ticking off boxes, they decided, let's blame the mom for how she raised him, and let's blame him for using drugs. But trial counsel didn't investigate enough to know if those things were true. And so in taking this approach, trial counsel totally missed Mr. McKane's true character and person and the signs their client suffered from serious mental health issues later in life. This court will hear evidence that Mr. McKane's family and friends universally describe him as sweet and caring, someone who loves his family deeply and has respect for his mom and sisters and aunties and his coaches. One teacher shared with us that he even considered adopting Mr. McKane in high school to help him escape poverty and violence in his neighborhood, all because Mr. McKane was a good kid with a bright future. The court will also hear that as Mr. McKane entered early adulthood, he struggled. Work was hard. Seeing family and friends became hard. Getting out of bed, putting on clean clothes, and combing his hair was hard. He obsessed over and drew pictures of aliens that would save our planet, accused his best friend and closest cousin of having an affair with a girlfriend they barely knew, and spent days alone in his room drawing his pictures and talking to a person that wasn't there. This court will hear from Mr. McKane's sister, Tasha, who witnessed her brother's struggles and was willing to tell the jury about them, had trial counsel built the relationship with her and asked her to testify. And finally, this court will hear from Dr. Scott Bender, who reviewed Mr. McKane's extensive life history the post-conviction team put together. And that included extensive social history records and nearly 24 lay witness statements. Dr. Bender also personally interviewed Mr. McKane. Dr. Bender will tell this court that Mr. McKane has a serious mental illness that causes him to experience delusions and paranoia, even about the people in his life he loves. But the jury never got to hear about this. In a death penalty case, we have to ensure clients receive competent representation by lawyers equipped to handle these serious cases and who are willing to take on the extraordinary investigation they're duty-bound to do. We have to ensure the jury knows what a person's life has been like before deciding to extinguish it. This court can only have confidence in the outcome of the jury's decision if it has confidence the jury received a whole and true picture of Mr. McKane's life story, his intentions, and his mental health. But the jury in this case didn't have that whole and true picture, and at times were fed misinformation. But things can be corrected now. There is an opportunity for this court to receive the evidence the jury should have had, the facts the jury should have had when making their impression of Mr. McKane. This court has a lot in front of it already, including our post-conviction application that raised several grounds for relief, and now over 100 exhibits in support of those claims. This hearing, however, is going to focus on the errors at the penalty phase of Mr. McKane's trial. And so at the end of this, I believe the court will see that Mr. McKane received ineffective assistance of counsel. The state presented misleading evidence at his trial, and I believe the court will grant Mr. McKane a new trial.
All right, State.
Judge, very briefly, this court is well aware of its role in this process, and Judge, I know I don't need to remind you of how habeas proceedings work. I know that, in a very real sense, we're here to build a record on this, and ultimately the decision will go to the Court of Criminal Appeals. That decision is made without emotion. That decision is made in an objective way. That decision is also made with the knowledge that once you get to this phase, the burden of proof shifts. The burden of proof is no longer on the state to show why Mr. McKane should be convicted or why his punishment should remain as it is. The burden is on Mr. McKane to come in and prove his claims. Under Maldonado, it is on the applicant to plead and prove facts which true would entitle him to relief. Under Ex parte Impe, the bare conclusory statements, sworn statements of the applicant are not enough. It has to be backed up by evidence. It has to be backed up by proof provided to this court. An applicant must plead and prove facts which entitle him to relief and must prove his claim by preponderance of the evidence when it comes to everything other than actual innocence, and that's from Ex parte Reins. There is a lot to break down with this particular case, but we're really talking about a few separate types of claims. The one that we anticipate that you're going to hear the most about, or the type that you're going to hear the most about, is ineffective assistance of counsel. This court is well aware of the standard that applies to ineffective assistance of counsel under Strickland v. Washington. First and foremost, that reasonableness standard, or that objective standard. Was it objectively unreasonable for counsel to undertake this action? Did counsel perform below the industry standard of what would be expected of attorneys in a similar situation? We do not believe that the evidence exists or that there is proof that counsel in this particular case was below that industry standard. We believe that in the evidence the court has already heard and in the documentation that the court has already received, that it has been shown that counsel has met that industry standard or did meet that industry standard at the time of the original proceeding, and we believe the evidence will show that. The second part of that Strickland standard is that it has to be that but for the errors of counsel, the outcome of the proceeding would have been different. And we do not believe that the evidence that is shown to this court will support that conclusion, that the outcome would have been different. We believe that that cannot be met, that burden cannot be met by applicant here. As to the notion of false evidence, there are two parts to a false evidence claim as well. The court's well aware of that. Under Argus and Giglio, the notion that first and foremost, for that first prong, you have to be able to show that the evidence was in fact false. It's not a notion that the evidence could be false or the possibility that the evidence is false. It is proof that this evidence is false, was in fact false. We do not believe that the evidence will support or that the proof provided in these hearings will show that that evidence was false. If the individual can show that that evidence was false, though, then we move in to a second outcome determinative prong. But for that evidence, would the outcome of the proceeding have been different? Would it have changed the outcome for the punishment faced in this case? Understanding all of the other evidence, understanding the totality of what this court and what the jury heard, would it have changed the outcome of the case? And we do not believe that it can be shown that it would have changed the outcome of this case. Ultimately, Judge, we are here to build a record on this. We know that you will be making a recommendation to the Court of Criminal Appeals. We know that you're going to be making credibility determinations, and we hope to do everything that we can to help you create that record and help you make those credibility determinations and to come to the correct recommendation there. We will do everything we can to hold applicant to his burden under Maldonado and under Reins. And we believe that the evidence does not support and cannot support the claims that are being made on this application. Thank you.
Can petitioner proceed with presentation of witnesses?
Yes.
The petitioner calls Ana Juarez.
I'm gonna swear you in, okay?
Yeah.
Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you may need to adjust the microphone. The whole thing, make sure we can hear you, okay?
Can you hear me?
Can you give us your name and spell it for the court reporter, please?
Ana Juarez, AnaJuarez.
Thank you, Your Honor. So, Ms. Juarez, I just want to start with some background information about you. Where do you live right now?
San Antonio,
How long have you lived in San Antonio?
my whole life.
Where'd you go to high school?
Fox Tech,
And what year did you graduate from Fox Tech?
2006.
After high school, did you attend any further schooling?
St. Philip's and Our Lady of the Lake University.
What did you study at those schools?
Bachelor's in psychology and criminal justice, and then master's in social work.
And where in San Antonio do you work right now?
Bear County Jail.
And what do you do at the Bear County Jail?
I'm a social worker there.
How long have you been employed that way?
3 years. I've been there 3 years.
Okay. So let's talk about why you're here today. Do you know someone by the name of Otis McKane?
Yes, sir.
How do you know Otis?
We met in 10th grade.
Okay, so about how long have you known him then?
That's over close to 20 years. Over 20 years. Yeah.
Is it somewhere in that vicinity? Yeah. And just to be clear, the school that the two of you went to was Fox Tech?
Correct. Fox Tech.
And where was Otis in relation to you?
He was in 10th grade because he graduated. Yeah, I think 10th grade. He was a year above me, so junior.
Okay, all right. So I want to talk for a minute about Fox Tech. Where in San Antonio was Fox Tech located?
Like almost in downtown area.
And as a school, what is Fox Tech like?
What do you mean?
Demographic-wise, what's the student body of Fox Tech like?
So they used to pull from like the east side of San Antonio and the west side, but the two areas were mainly like poverty areas. So most of the population there was income, like the income wasn't great. High rate of pregnancy, things like that there.
Was there much funding for facilities and textbooks and things of that nature?
No, that wasn't one of the good schools to go to.
So let's talk about your friendship with Otis. You mentioned that you weren't in the same year as Otis. How did you end up getting to know him?
Just through other friends, and we played sports as well.
Okay. What were your first impressions of Otis when you started to get to know him?
Well, he was friendly. He was very calm. He wasn't aggressive like other guys in school. He was like a nerdy but cool guy. But yes.
And you mentioned this a little bit, but how did Otis's behavior towards you compared to other boys his age at Fox Tech?
Oh, just calm, very friendly, and not aggressive towards just like other guys at the school at that point.
Mm-hmm. What did Otis look like back then?
So he was very attractive, very clean, took care of himself very well. He played sports, so he was one of like the top guys in the school. So he took care of himself.
Mm-hmm. Did it seem like he took pride in the way he looked?
Yeah, definitely.
Did he have any particular haircuts or?
No, I mean he was just always really. He looked nice all the time. He took care of his haircuts. You know, that was important to them.
Was there at any point when you were interested in potentially dating Otis?
Yes, we were talking for a little bit.
Mm-hmm. Do you know if Otis was interested in dating you?
Yeah, I think so.
Were there any other boys that you were interested in at the time?
Yes, there was another individual that I also spoke to in 10th grade.
So around the same time you're interested in both Otis and another guy?
Correct. Yes, sir.
How did that love triangle play out?
Not great. We used to, everyone at the school would go to this recreational Tobin Center, and I was there with the other guy in high school, just for like a basketball game, and Otis was there and he came to say hi, and then the other guy, which was more of a bad boy, try to make fun of Otis, try to call him out, made fun of him for me be there with him, so I felt pretty bad. But
so just to be clear, at that point you had decided to go with this other
correct
kid instead of Otis?
Yes, sir.
Okay. What was Otis's reaction to that guy calling him out in front of everybody else?
I think he was embarrassed, but he was just trying to calm him. He was trying to calm him down. He was telling him, "I'm just trying to say hi. Like I'm not trying to start nothing." But the guy, I think, because all his friends were there, he was trying to get him to react and I guess fight.
Yeah, trying to pick a fight with Otis.
Yeah. Mm-hmm.
Did Otis engage and get into a fight with that?
No. Otis walked away. He tried to calm it down, and he was like, "I'll just see you later," and he just walked away.
After that point, did you have any conversations with Otis about you picking that guy over him?
Yes. When I saw him at school, I thought he was going to be mad, or maybe say some mean things. But he told me that he understood that, like, we're all allowed to have our feelings. He's like, "I understand that that's who you want to be with." He's like, "We could still be friends," and we stayed friends.
And why did you stay friends with Otis?
Because he was really sweet. He was very kind and very understanding. I mean, after that, you would think most guys would respond in an ugly way, but he didn't.
Okay. So you mentioned before that Otis was involved in sports. What sports did Otis play?
Basketball and football.
And how was Otis as an athlete?
Great.
Yeah.
One of the top athletes at the school. Mm-hmm.
Was he passionate about sports?
Yes, very passionate.
Would you say that he was involved in the team dynamic on his sports teams?
Yeah, definitely. That's what kept them together. That's what kept them going in school.
Mm-hmm. Was Otis a troublemaker as a student?
No.
Was he popular at school?
Very popular.
How did he become popular?
Sports. Yeah, sports.
So we talked about Otis being a little kinder and nicer to you than a lot of boys his age. Was he different in temperament from a lot of the other kids?
Right. He was very calm. He wasn't vulgar. He wasn't disrespectful like some of the other guys. Again, even being turned down, he was still the same respectful, calm. And again, the vulgar part. A lot of guys at that age can be very aggressive in that way, but he wasn't.
Mm-hmm. Can you remember any specific instances of Otis being the calm and collected one when everybody else is a little hot-headed?
Yeah. There was a game, and I can't remember what school we were playing against, but most of the schools we played against, it was pretty aggressive. But someone started a fight or an argument off of something, and I just remember him trying to calm down his teammates. He pulled away like 2 or 3 guys. Then I think teachers got involved and then stopped it all together. But I didn't see. Otis was trying to pull people away, and I think I always remember him saying it's not worth it. But I think it was because of who we were playing against.
Mm-hmm. So Otis was trying to talk down on
right,
the guys.
And he pulled down, I think, one of his closer friends.
So I want to talk for a minute about what you know about Otis's home life while he was in high school.
Mm-hmm.
What knowledge do you have of what it was like for Otis at home?
It wasn't stable. It wasn't a strong foundation.
Mm-hmm.
There was a lot of movement going on,
Mm-hmm.
just not a lot of stability.
Did it seem like Otis had a lot of parental support or financial support from home?
No.
What makes you say that?
Well, I know about times where people would give him money or help him out with things, or he would stay at different places. I know Mom was a single, hard-working mom, so I think she did the best that she could with what she had in front of her. But that pulls you away from, I guess, other motherly responsibilities.
And yeah, you mentioned that Otis's mom was single and hardworking. How did Otis talk about his mom?
He loved her. I think he had a lot of respect for her. I don't think he saw where she lacked in the areas that she couldn't provide.
That was all just normal to Otis?
Yeah, that was his reality.
So let's move on after graduation from high school. Did Otis graduate from Fox Tech?
Yes, sir.
Did you stay in contact with him after you graduated?
Yes, sir.
Why'd you do that?
Because we were friends, and he was one of the nice guys.
How did you stay in contact with Otis?
Just communicating. We would see each other here and there. Phone, text conversations.
So I want to talk about some events that happened a while after the two of you graduated. Do you remember a time when Otis got into some trouble in Concho County?
Yes, sir.
Do you recall what happened?
I think it was like a drug charge.
How did you find out about that?
He reached out, and then I talked to Mom about it too.
Was there anything that you did for Otis while he was in jail in Concho County?
Yeah, I sent him money, and then we went to go pick him up when he was being released.
When you say we, who's
me and his mom.
Okay. So you ended up giving his mom a ride to Concho County?
Correct.
About how long is the drive to Concho County?
I think about 3 hours.
3 hours one way?
Yeah, correct.
How did Otis react to you giving his mom a 3-hour one-way ride to pick him up?
He was very thankful, and he kept saying, if there's ever anything I need, he would be there for me.
And I guess just to back up, why did you give his mom a ride? Why did she need a ride?
If I remember correctly, she didn't have the vehicle or a working vehicle to get there, and he didn't have a way of getting home. He didn't have money.
When you did that, did it seem like a big gesture on your part?
No.
But Otis was very thankful?
Yeah, Otis was he felt bad that I even had to do that, but it was okay.
So as the years progressed up after high school, did you begin to notice some changes in Otis?
A lot of changes.
In terms of his physical appearance, how did Otis change from that kid that was well dressed in high school?
He didn't take care of himself as much as he used to. Clothes wise, shoes is very important to gentlemen, and I remember seeing his shoes and they weren't as clean, and I was like, man, I know that's something he took pride in. He didn't take care of his hair the way he used to. He didn't look like Otis.
In terms of talking and speaking with Otis, were there changes in the way that he spoke?
Correct. Yes, I feel like there was a slower speech pattern, delayed thought process sometimes. It took him a second to put his thoughts together. I think he couldn't articulate himself as quickly as he used to.
Over time, did Otis get better or worse?
Worse. Worse.
Were there any particular things in Otis's life that it seemed he really struggled with?
Yes. I know financially that there were struggles there, but also he was in a very toxic relationship. And again, his impaired thought process, things changed there with how he viewed the world. And I feel like he detached from for me, I guess for myself, he detached, and we didn't communicate as much as we used to, but there was really no clear reason why.
And so Otis was not reaching out to you to speak?
No.
You mentioned a toxic relationship. Who was the toxic relationship with?
His child's mother.
Was Otis in high school the kind of guy that had toxic relationships?
No.
Did you ever speak with Otis about trying to get visitation with his child.
Yes, we spoke on it, that he was just distraught that he wasn't able to connect with his child.
When you spoke with Otis, did you talk about, well, I'll withdraw that. When you spoke with Otis about not being able to see his child, how would you describe his demeanor?
A lot of mistrust, a lot of paranoia, a lot of I want to say disconnection with reality, if that makes sense.
Yeah. Did you try to talk Otis through some of that paranoia?
Right, like logically break things down for him.
Did it seem like Otis was able to be talked through that paranoia?
No, not at all.
I just have a few more questions about your thoughts on Otis during this period of his life.
Mm-hmm.
So we discussed earlier that you're a social worker at the Bear County Jail, right?
Yes, sir.
In that role, have you had the opportunity to interact with people struggling with mental health issues?
Yes, sir.
Looking back on your interactions with Otis during that time period, does he remind you, did his behavior remind you of anything?
Yes.
What did it remind you of?
Someone like that, we probably would have in a more like a mentally ill unit.
I want to finish up by asking you about Otis's trial, okay?
Mm-hmm.
Did you see any of Otis's trial?
Yes, sir.
When you were at the trial, did you see any of Otis's old friends from high school?
Yes, sir.
Do you remember who you saw?
Reginald and Maurice.
Did you ever meet anyone from Mr. McKane's or from Otis's defense team before trial?
No, sir.
Are you aware of whether or not any of them ever tried to reach out to you?
No, sir.
When did you become involved in Otis's case?
When I was reached out to someone after his conviction by y'all's team.
If someone had contacted you before Otis's trial, would you have shared with them what you shared with the judge today?
I would have shared a lot, yes, sir.
Would you have been willing to testify at Otis's trial and say what you said today to the jury?
Yes, sir.
Ms. Juarez, was it easy to see Otis change the way he did transitioning into adulthood?
No.
Was it surprising to you when you found out that Otis had been charged with this offense?
Yes, sir.
I'm sorry, there's a box of Kleenex behind the screen right there.
I see it right there. Yes, I was surprised.
Have you continued to stay in contact with Otis?
Yes, sir.
And after all you saw him change, after all that you saw change in him, and after all that's happened, why do you still keep in contact with Otis?
Because I care about him, and I know the good in him.
Judge, I have nothing further. I'll pass the witness.
Thank you, Judge. Ms. Juarez, my name is Matt Howard. Can you hear me all right?
I can hear you, yes, sir.
Okay, we're not using the mics up here
Okay,
this morning.
I can hear you.
I just have a few questions for you. So you mentioned that you've been working at the jail for about 3 years as a social worker.
Yes, sir.
How many, I don't know, would you call them clients?
Patients?
Patients?
Oh,
Okay.
sorry.
How many patients would you say that you interview regularly?
On my caseload or
Yeah.
daily?
Yeah, let's say daily.
I see about 10 to 17 a day.
Okay. And when you're interviewing those 10 to 17 patients, are you diagnosing issues that they may have?
No. So that's the assessment part when they're initially coming in. We're doing all symptoms and then notating for the psychiatrist.
And so you notate the symptoms and then it goes to a medical professional to make the official diagnosis.
Correct, sir.
Okay. Have you had do you know after the fact then?
Yes, sir.
What the result of the diagnosis is?
Correct, because we continue to follow up with them if they're on our caseload.
Have you had instance where you have diagnosed certain, or not diagnosed, but identified certain symptoms that you feel like are consistent with the diagnosis, but then it comes back with a different diagnosis?
Yes, sir.
How often has that happened?
I don't know. I couldn't give you a number and be honest with it.
Okay. I appreciate what you're doing at the jail, and I'm not trying to make light of it in any way. But when you interview
Mm-hmm.
someone, are you looking for certain symptoms or certain tells about some sort of mental issue that they may be having?
Yes, sir.
And how often would you say you're able to identify those in the clients that you're, or in the patients that you're interviewing?
Almost every time.
Okay. So every interview that you're doing, you're able to.
We're looking for the symptoms, even if they're not giving it to us.
Okay. Why? And this is going to sound like a larger question. Why are you here today?
Because I care for him. He's my friend of 20 plus years.
So you care for Mr. McKane, and that's why you're here.
Correct.
Is it fair to say that you don't want Mr. McKane to be in prison?
No, that's not valid.
Okay, and why is that not valid?
Because I'm not here to judge if he should be there or not. That's not why I'm here.
Okay. So do you think he should be in prison then?
I think he should have a fair trial and the jury decide for him.
Do you keep up with Mr. McKane's family today?
Some of them, yes.
Did you speak with them in preparation for this setting?
No, sir.
Did you do anything in preparation for today's setting?
Like meet with the lawyers?
Yes.
Oh.
Well, and have you reviewed anything else, done anything else in preparation for this?
No. I met with the lawyers regarding like why I'm here.
I know that your affidavit in a moment ago in testimony, you mentioned noticing a change in Mr. McKane after the
Yes.
time of high school. Have
Yes,
you
sir.
ever diagnosed Mr. McKane or had the opportunity to observe in a clinical setting?
No, sir.
Judge, I guess I'd object. She didn't offer a diagnosis in her direct examination. I'm not sure that we need to go this far down the road in terms of her ability to diagnose. She's not being offered as an expert.
And I'm not asking about the ability to diagnose. I just asked if she had sat down and had the opportunity to evaluate Mr. McKane.
Overruled.
So that's the question. Have you had the opportunity to sit down and evaluate Mr. McKane?
No, sir. I wouldn't do that because he's a friend.
And why would the fact that he's a friend mean that you shouldn't evaluate him?
That goes against our code of ethics. We don't treat our family or friends.
That being said, your affidavit does offer an opinion as to behavior and things you observed about his behavior, correct?
Correct.
So why does your code of ethics say you can't evaluate family and friends?
Because there's emotion there, right? So we may not see things completely for what they are.
Okay. And would you agree that, like you said a moment ago, there's a degree of emotion that goes into the fact that you've known Mr. McKane since 10th grade?
Yes, sir.
I just have a few more questions for you, Ms. Juarez.
Yes, sir.
You mentioned the changes that took place in Mr. McKane after high school.
Yes, sir.
Did you form an opinion as to what could have caused those changes?
Judge, again, I guess I object. She's not qualified as an expert to offer a diagnostic opinion. She has previously testified to, I guess, a lay opinion, and that's been asked and answered.
And I can rephrase, Judge.
Okay.
Ms. Juarez, as Mr. McKane's friend, Did you notice any changes in his behavior that you thought might be contributing to that change in appearance, the change that he was or how he was acting?
I'm sorry, I don't understand.
Did you think that you mentioned drug use a moment ago, for instance? Did you believe that might have played a role?
I'd object. I think that's a misrepresentation of the.
I don't
testimony.
think I said.
Hold on a second. Just so you know, I didn't give you these instructions.
Okay.
But when one attorney stands up and objects, don't respond at all until we let
Okay.
you know whether or not you can.
Okay.
All right, you can continue.
Judge, I guess I just asked the state to identify where drug use was mentioned in prior testimony.
And I can rephrase again, Judge.
Okay.
Ms. Juarez, you mentioned going with Mr. McCain's mom to pick up Mr. McCain from jail in another county.
Yes, sir.
Do you know what he was in jail for?
I just know it was a drug charge.
Okay. Do you believe that that was kind of a turning point in as far as what you observed about him? You know, the change between high school and the change after high school?
I don't think that was when I saw the turning point.
When did that turning point take place?
Early 20s, maybe. I can't remember, but I know I noticed the change before the pickup in the other county.
Your affidavit mentions, seems to indicate that after the time of that arrest and the assistance that you provided to Mr. McCain's mom,
Yes, sir.
that you started to notice those changes. Is that accurate?
Yes, sir.
And you mentioned that you and he were close until that point in time, and clearly close enough that you wanted to assist his mother with that 3-hour drive, and presumably a 3-hour drive back. Did you ever have a conversation with Mr. McCain about what was going on with him at that point?
I know we did, but I don't remember like what that conversation was like.
So no indication from him about what had changed in his life between high school and adulthood?
I can't remember that. Yeah, I can't remember.
Switching gears just a little bit, and this is kind of the last place that I'd like to go.
Yes, sir.
You mentioned a moment ago in direct testimony about the relationship that Mr. McCain had with the mother of his child, and you described that as a toxic relationship. What do you mean by that?
I just remember him telling me how they just could not see eye to eye on a lot of things, and they would cause each other turmoil, pain, name calling. It just wasn't a healthy relationship from our conversations.
Are you aware of any violence that was perpetrated in that relationship?
No, sir.
Would you be surprised to learn that there was a protective order against Mr. McCain?
No, sir.
Why would that not be surprising?
Just because I know they didn't get along very well. I knew it was a lot of turmoil there.
And is that a stark contrast to the description of that you gave of his personality in high school?
And no, I am referring to what he said she would do. So I don't know what transpired in the relationship, but I know they didn't get along so much that she did that. I don't know the truth behind that because I don't know what happened. But if you're referring to if I personally would ever think to put a protective order against him, then no, I don't think one would ever be needed. I just don't know their relationship.
But it wouldn't surprise you to learn that there was a protective order against Mr. McKane.
Correct, because of how unhealthy their relationship was, but not because he's a violent person. Like, I don't know if I'm wording that properly.
We'll pass the witness.
Nothing further, Judge.
All right, the rules have been invoked. Has that been explained to you? Yes, no?
No.
You're not allowed to discuss your testimony with anybody else who could be a witness or is a witness in this hearing.
Of course.
Or their testimony. You can talk to the lawyers about it if you want, but only the lawyers, okay?
Okay, yes, sir.
All right,
Okay,
Judge.
thank you.
Judge, can we take about 3 minutes?
All right, let's take a short break.
Just briefly, Your Honor, we would ask that Ms. Juarez is released from her subpoena.
Y'all good with that?
We don't believe we have need to recall her at this point.
All right, then we'll do that.
Thank you.
All right, let's take a short break.
Okay, someone's staying here.
guys may want to mark these, unless they're marked somewhere else. You may
On
want
the
to mark
bottom
these.
right?
Yeah, just, they are marked?
Yes,
Oh, I
actually,
see.
yeah.
Fancy.
Pre-marked,
Pre-marked.
you know, yes.
Don't get used to it.
Right.
Hey, Sarah.
No.
We brought stickers too.
No, you're good.
Sarah.
You're good.
Sorry to bother you.
I know you started maybe one of the
Sheriff's office wants to return this guy's phone.
Oh, they're admitted? Oh, they're admitted?
Why do we want this?
They're not admitted on our records.
I don't know why I wanted it.
I thought we're talking about. Yeah, I mean, just because they're not admitted.
What are you trying to do?
File record,
That's not
as
right.
far as this record that I prepared, I need one. I will. Okay, so it's like a 1 through 107, just to formally admit them in this hearing.
Yes.
If you want to know how to do this hearing.
I thought we accidentally
Good to
said
see you.
that.
Have a nice week.
One through 108.
Well, you started with 108 as the first one that you offered.
Oh, okay.
And then 109 through 115 in the physical copies.
Let me correct that right now. In the 1 through 108 is part of the record. We didn't bring, well, we have copies of some of it. It'll be on the flash drive later.
Yeah.
I will correct that on the record right now and we'll
Perfect.
formally move those in.
Okay, thank you.
Thank you.
Thanks, Judge.
You're welcome. Good timing. It was good timing. I bought a coffee this morning.
You know, as you do. And then, yeah, and then 107.
Starting with exhibit 1. So the clerk's office already has it. But I mean, I guess.
She has to move them.
No, I'm just saying, if the clerk's office has them, that's fine, but they won't be a part of my record
Right.
unless they are admitted, offered and admitted in this hearing.
So
I'd like
let's
to
do that, yeah.
Yeah, okay.
Okay.
Yeah.
Oh, yeah.
Yeah. Oh, yeah, yeah.
Y'all let me know when y'all are ready.
Thank you. Just one moment, please, Your Honor. Your Honor, we are ready to proceed when the court is.
All right, back on the record, State of Texas versus Otis McKane, or Henry Otis McKane. All right, applicants you can consider, or petitioners.
And really quick, Your Honor, I may have made a mistake earlier. In introducing the applicant's exhibits, I intended to introduce applicant's exhibit 1 through 107 as well to be admitted.
And Judge, we spoke about this off the record a moment ago. I believe that we've seen all of these exhibits. They are already in the possession of the district clerk's office, but we'd like to make sure that they become part of the record of this hearing today and that they are included in the court reporter's record here. We have no objection to those exhibits being admitted.
All right, then they're admitted. You're welcome.
Applicant will now call Dr. Matthew Fabian.
Let's see. I'm going to swear you in. All right. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right. You may need to adjust the microphone. Make sure we can all hear you.
Is this okay?
Yeah, it's pretty powerful.
Okay.
You don't need to get too close. All right. Can you introduce yourself to us? Spell your name for the court reporter.
Yes, my name is Matthew Fabian. First name is spelled M-A-T-T-H-E-W. Last name is spelled Fabian, F-A-U-B-I-O-N.
All right, applicant.
Good morning, Dr. Fabian.
Morning.
Are you currently employed?
Yes.
Where are you currently employed?
Currently, I'm employed as the clinical director for West Texas Center's local mental health authority. It's an outpatient community mental health center covering 23 counties in West Texas.
What do you do there?
So I'm in charge of overseeing all clinical services for that agency, but I also do clinical work. So Monday through Friday, I see patients in that catchment area. We work by telemedicine because it is such a large catchment area. So I'll see folks across all of our clinics in all of the counties within the area.
Your Honor, may I approach the witness?
Yes.
May I approach the bench as well?
Yes.
Dr. Fabian, I'm handing you what's been marked as Applicant's Exhibit 116. Can you identify what that document is?
Yes, this document is my most recent CV or resume.
Applicant would move to admit Applicant's Exhibit 116.
No objections, Your Honor.
It's admitted.
Dr. Fabian, can you describe your educational background?
So my undergraduate education was at Oklahoma State University from 1990 to 1994. And then I went to medical school at the University of Oklahoma from 1994 to 1998, where I received my MD degree, my doctorate of medicine. Then I joined the military as a way to pay for medical school. So I came to San Antonio in 1998 to complete a psychiatry residency program, which is a 4-year program with specialized training in psychiatry. I completed that program, and then in 2002 and 2003, I went and did a subspecialty training program at the University of South Carolina in the field of forensic psychiatry. Then I returned from my time at the University of South Carolina and began serving active duty in the United States Air Force.
How long were you in the military?
I was in the military for about 10 years, 10 and a half years.
Can you tell us more about your work background in psychiatry?
So when I came back from the subspecialty training at the University of South Carolina, I was on active duty and I was stationed at what was then Lackland Air Force Base and worked out of Wilford Hall, which was the large medical center there on base. And my first job in the military was overseeing the outpatient mental health clinic. So I did that, and then in 2003 and 2004, I had my first deployment over to the Middle East. And at that time I was stationed out of a base in Qatar and had a wide-ranging area of responsibility and did a diverse number of duties on deployment. Then when I returned from that Air Force deployment, I assumed care of the consultation liaison service at Wilford Hall Medical Center. And basically what that was that I oversaw provision of psychiatric consultative services to folks who maybe were admitted to a medical unit or a surgical unit or who were seen in the emergency room. So I did that job for a while. With seniority came some promotions, and I ultimately served as the department chairperson for psychiatry there at Wilford Hall, as well as the associate residency training director, meaning that I was responsible for the military piece of the psychiatry residency training program. Then I had a second deployment in 2006-2007, during which time I oversaw a combat stress unit and also had some other responsibilities within Iraq.
Where do you hold a medical license?
I'm currently licensed in both Texas and Oklahoma.
Have you been recognized by a court before as an expert in psychiatry?
Yes.
Dr. Fabian, do you do forensic work and clinical work?
Yes.
How much of each?
About 80% clinical and 20% forensic.
What is the difference between forensic work and clinical work?
So clinical mental health work is, well, seeing patients and taking care of people. You know, I'll see folks, make diagnostic assessments, initiate treatment plans, prescribe medications, Often we'll see them over time, what we call longitudinal care, where you'll see people multiple times over time. Currently in my job duties at West Texas Centers, I see both adults and children because I'm responsible for the provision of what we call crisis prescriber services. So when folks within our large catchment end up in the emergency room or come to the attention of law enforcement and need an appointment with a psychiatrist sooner rather than later, they come see me. So I see about 70% adults clinically and about 30% kids clinically through West Texas Centers. Then the forensic work is evaluation and assessment. So I'll be asked to do, to answer a question for the court, like for instance, to render an opinion on whether an individual is competent to stand trial or not, or whether someone was sane at the time of a charged offense. So with respect to my forensic work, I not only do private forensic work, but I also provide forensic services for the jails in West Texas, and that's done through contract with the local mental health authority.
At this time, applicant would seek to have Dr. Fabian admitted as an expert in psychiatry.
Objection.
All right, he's so admitted.
Dr. Fabian, how did you originally become involved in Mr. McKane's case?
So I was approached by the Bexar County District Attorney's Office, and I'm not sure how they got my name or why they wanted to speak with me, but they approached me maybe in the fall of 2020 or early 2021 and asked if I had availability to potentially assist them in a case. I met with them, discussed my qualifications and background with them, very similarly to what I'm doing right now. And then they contacted me and let me know that they wanted me to perform an evaluation of Mr. McKane.
What all were you asked to do in this case by the state?
So I've been doing forensic work for, almost 25 years now. And in Mr. McKane's case, there was an order from October of 2020 that limited what I could speak with Mr. McKane about and limited the types of documentation I could review and who I could even speak with about my evaluation. So I performed a general diagnostic assessment of Mr. McKane.
What was the limitation on your evaluation?
So, and you'll have to forgive me, I don't have the original order in front of me, but to the best of my recollection, the order forbade me or other experts, to my understanding, of speaking with Mr. McKane about anything to do with the, at that time, alleged offense. I also could not talk with either legal team about the offense. And there was some question about report preparation. And ultimately, I did prepare a report detailing my assessment, and a copy of that report was submitted directly to the judge.
Did the state also provide you with materials to review?
Yes.
To the best of your recollection, what generally were those materials?
Some of the materials included letters from Mr. McKane to an individual outside the jail. There was a document with a statement from a law enforcement officer made around the time of Mr. McKane's arrest. I had access to some records detailing his jail-based treatment, jail medical records, if you will. They highly emphasized what happened in 2020. Maybe there were 250 pages of information, mostly more recent and not as, there were some earlier records, but most were from 2020 with respect to the medical records. Then I had court records involving previous charges and convictions, to include a juvenile record from 1999, then records from the San Angelo area regarding a drug arrest and conviction in 2006, and then a domestic violence charge conviction in 2012.
And I believe you mentioned this, but did you conduct an in-person interview of Mr. McKane?
Yes, I did.
Do you recall the date that that evaluation took place?
The 11th of February of 2021.
And
Yes.
After you completed your report, did you let the state know you had finished the report?
To the best of my recollection, I did, and I awaited additional direction. As I said, I'm not an attorney, and I didn't completely understand what I could and couldn't do, and I was sensitive about violating the order.
Was there anyone you did send a copy of your report to?
Yes, I ultimately sent a copy of the report to the, my understanding was the court coordinator, who, in accordance with the order, again, to the best of my recollection, the report was to be sealed until such a time when it wasn't.
Do you recall around the time period that you had sent the report to the court coordinator?
Probably early May 2021.
Around this time period, as we move kind of into the summer, June and July 2020, I understand that you had some personal things going on in your life?
Yes, ma'am.
If you're comfortable sharing with some of what had happened.
Oh, of course. So on the 23rd of July 2021, so almost 4 years ago now to the day, I was going to Austin. At that time, I was also serving as a governor's appointee, consulting with the Texas Department of Criminal Justice regarding care of the mentally ill inmate in Texas. And there was a face-to-face meeting. We hadn't had a face-to-face meeting in a while because of COVID. So myself and my partner, who also happens to be a forensic psychiatrist, were going up to Austin, and she was going to drive and I was going to review some materials from the meeting. And she picked me up, and her speech was not right, and things just weren't as they should be. I was concerned that she was having a stroke or that something medical had happened. So called the folks in Austin and said I wouldn't be there because of a medical issue, and took her to the emergency room, where ultimately she was diagnosed with a grapefruit-sized brain tumor and admitted to a specialty hospital that day. Then she had a couple of neurosurgical procedures within the next few days and spent some time in the intensive care unit.
During this time, just to kind of orient everyone, Mr. McKane's trial proceedings are starting to begin. During that time, were you and the state in communication regarding whether they may need to call you to testify at Mr. McKane's trial?
Yes.
Was there an attorney for was there an attorney for the state that you mostly communicated with?
It was primarily Mr. Del Prado.
Did you and Mr. How did you and Mr. Del Prado generally communicate?
Around this time, it was often by text because I'm in the hospital during the day, so we commonly communicate via text.
Dr. Fabian, did Mr. Del Prado eventually communicate with you and inform you that Dr. Rambula had formed an opinion about Mr. McKane in this case?
Yes.
What was that communication?
This would have been probably in early August, and Mr. Del Prado indicated to me that...
Objection, Your Honor, hearsay.
Response?
Your Honor, we're going to ask for a little bit of leeway in a writ proceeding. There's no jury here. We want the judge, you as the court to have as much evidence as possible to understand the circumstances of how Dr. Rambula came to testify. And so we're going to ask for a little bit of leeway here. And I would also say that at this point, it's not offered for the truth of the matter, but just the circumstances under which Dr. Fabian came to testify or not.
Overrule.
Okay, Dr. Fabian, go ahead. Tell us what the communication was regarding Dr. Rambula's opinion.
So this would have been in early August of 2021, and Mr. Del Prado had indicated to me that Dr. Rambula opined that Mr. McKane had antisocial personality disorder and inquired about the significance of me not reaching that diagnosis.
Did you share with him the significance of you not reaching that diagnosis?
That I didn't believe that Mr. McKane had antisocial personality disorder based on my evaluation. So through this time, I'm standing by. Not always is trial testimony necessary, and I was awaiting direction from the DA's office about how to next proceed, and I was ultimately informed that my testimony would not be necessary and that they would be moving forward with Dr. Arambula.
When you informed Mr. Del Prado that you did not reach the same diagnosis as Dr. Arambula, do you recall about how long it took before Mr. Del Prado reached back out to you?
Oh, it was pretty quick. It was later that same evening.
And to be clear, Mr. Del Prado let you know that he would not need you to testify?
Yes.
At that point, did you know whether Dr. Arambula had met with Mr. McKane personally or not?
No.
Did you eventually learn that Dr. Arambula had, in fact, not met with Mr. McKane?
Yes.
Did the state ever ask you to testify at any point in Mr. McKane's trial?
No.
If the state had asked you to testify at Mr. McKane's trial, would you have?
Yes.
Did Mr. McKane's defense attorneys ever contact you or reach out to you?
No.
If Mr. McKane's trial attorneys had subpoenaed you or asked you to testify at any part of Mr. McKane's trial proceedings, would you have been available to do so?
Absolutely. I would have wanted to get clarification on what I could say and such because of the limitations from the initial order, but absolutely I was available.
And so your testimony today is the first time this court will get to hear from you about your evaluation of Mr. McKane.
To my knowledge, yes.
Dr. Fabian, did you become re-involved in this case at some point?
Yes.
How did you become involved?
So I believe it was your office, or maybe you directly, that reached out to me maybe a year and a half ago. So,
Since then, were you asked by my office to review additional information pertaining to Mr. McKane?
yes.
May I approach the bench?
Yes.
This is an exhibit we intend to offer shortly. Dr. Fabian, I'm handing you what's been marked as Applicant's Exhibit 117. Will you take a look at that document and tell me what that is?
Yes, this document appears to detail the individual PDF files that you had sent me for my review.
Does that appear to be an accurate list of the materials sent to you by my office?
Yes.
Applicant would move to admit Applicant's Exhibit 117.
Objections, Your Honor.
It's admitted.
Dr. Fabian, the information provided to you by my office, is that the type of information that mental health professionals in your field typically rely upon to reach opinions?
Yes.
Is there a general axiom in the mental health field regarding materials received in reaching opinions?
So, in general, the more information we have, the better. You're then able to kind of weigh the validity or truthfulness, consistency of records, the more pieces of information that you have. So the more information, in general, the better the opinion.
Dr. Fabian, I want to talk a little bit more about the types of information that's relevant to conducting a reliable evaluation and reaching a more reliable opinion. do the ethical guidelines for psychiatrists require psychiatrists to at least attempt to conduct an in-person interview with the person they're evaluating, or at least speak with them?
So just for clarification, are we referencing the ethical guidelines specific to psychiatry or specific to forensic psychiatry? Because from a forensic psychiatrist's standpoint, the ethical guidelines that apply to my subspecialty and to evaluations like this require the provider to make an effort or ask to evaluate someone.
Why is it important to speak with the person being evaluated?
So if possible, it's good to speak with the person being evaluated, because then you can weigh not only what they say, but how they say it and how they interact, and being able to listen to how someone tells their story, for example, can be very helpful to observe their mannerisms, their actions. So there's a great deal of information that can be gained both directly and indirectly from evaluating an individual personally.
Can it be important to both conduct an in-person evaluation and have collateral information when determining whether the individual you're evaluating has a personality disorder?
Absolutely.
Why is that?
So in general, in assessments, if you can have collateral information, it's helpful in reaching a diagnosis, right? Because an individual may present only their side of things. And sometimes folks don't have a full awareness of their actions, right? Sometimes the people around them may see things that they don't. So from a diagnostic standpoint, having supporting information, particularly in a forensic setting, is important.
Are there usually certain types of collateral information you review?
I routinely will review, of course, police reports, information from the court, witness statements, medical records, things of that nature.
And that's an important part of the evaluation process?
Yes.
Can collateral information provide context to statements made during in-person interview or observations you have about the person's mental health?
Absolutely.
And if you're limited in your access to information, can that impact your diagnosis?
Yes.
May I have just 1 moment, Ryan?
Yes.
Thank you. Dr. Fabian, I want to return to your initial evaluation of Mr. McKane. To be clear, did you conduct an in-person evaluation of Mr. McKane?
Yes.
How long did you meet with Mr. McKane for?
I met with Mr. McKane for about 5 hours total. I met with him beginning, in the courtroom actually, and we met in the morning, and then took a break for lunch and came back and met in the afternoon.
Was there anyone else present in the room with y'all?
There was at least one bailiff, was my understanding, and there may have been 2. I can't remember.
Did you have the opportunity to observe any interactions between Mr. McKane and the bailiffs?
Just when he left the courtroom for the lunch break and when he returned afterwards.
How did those interactions seem?
There was nothing notable.
In your interview with Mr. McKane, what types of questions did you ask?
So for Mr. McKane's interview, because it was a general diagnostic assessment, I started by just having Mr. McKane tell me his story. And that type of unstructured evaluation allows oftentimes the evaluee to settle in, because before I ever got started with Mr. McKane, I informed him that the evaluation was requested by the district attorney's office, and that I may have to write a report, and that others may see that report, so that what we were discussing was not necessarily confidential. So that can be daunting to someone facing charges. So I started with generally emotionally neutral things. You know, what's your name? When were you born? Where did you grow up? You know, tell me about school. Tell me about relationships. So I may guide with general topics, but I allowed Mr. McKane to tell me his story in a fairly unstructured, free-form way.
And what is the purpose of those questions?
So one, it's eliciting information. So getting Mr. McKane's perspective on things, right? When I ask about what someone's childhood is like, they don't necessarily present an objective viewpoint of their childhood. They present what they remember or what their childhood was like from their perspective. So it was important to get kind of what his view on these things were. Secondly, by allowing him to tell his story in a very free-form way, I was able to assess for his ability to tell me a logical, coherent story that made sense, and assess his thought processes, right? How he was thinking, how he was communicating, as well as the manner in which he communicated. So asking questions about school, upbringing, relationships with family, relationships with friends, girlfriends, work history, legal involvement.
Did Mr. McKane share with you information about his background and upbringing?
Yes.
What are some of the things you recall that he shared about his background and environment?
So Mr. McKane was very open with me. He was very polite, which stood out because not always are evaluees polite in those types of settings. He told me about his upbringing, that he grew up in a very poor family, but that his mother worked and his mother was gone a lot, so he was responsible oftentimes for taking care of siblings or watching over siblings. He talked with me about school being almost a necessary evil, that he wanted to use school to an end, as a means to an end, to ultimately play professional sports. But he talked a lot about his accomplishments in athletics and what his future plans were at that time. Talked with me about his school performance, and you know, that he wasn't the best student, but that he was, you know, a good enough student to play sports. And so I would ask about general topics like school, relationships, family, and then allow Mr. McKane to tell me about that, and then ask clarifying questions as necessary.
Before we get into any kind of diagnostic impressions, what were your general impressions of Mr. McKane? What was it like talking with him and interacting with him?
So as I mentioned previously, Mr. McKane was very engaging and participatory in the evaluation. Not every evaluee is that way, particularly if I'm affiliated with the district attorney's office, for example. So he was very open and very talkative. I often just provided general topics like, tell me about your family, and he would talk with me at length without me having to continually prompt for additional information or questions.
Dr. Fabian, let's talk a little bit more about some of the things you learned from Mr. McKane by speaking directly to him. Did you consider Mr. McKane's criminal history as part of your evaluation?
Yes.
And more specifically for right now, did you consider his involvement in selling drugs?
Yes.
Did y'all discuss his selling drugs?
Yes.
How did Mr. McKane talk about that time in his life?
I'm not sure I understand exactly what time frame.
Did Mr. McKane, so Mr. McKane talked about the times he sold drugs in his life.
Yes.
Did he share with you why he sold drugs?
It was financially lucrative, and also at the same time, Mr. McKane had a significant substance use problem. And oftentimes individuals who are using the substance will sell the substance in an effort to fund their own use.
Did Mr. McKane also indicate that he was supporting his family and helping his mom and sisters out financially?
Yes, that was my understanding.
Did the circumstances of Mr. McKane's relationship with his former girlfriend, Sahara, come up?
Yes.
How did he describe the relationship with Sahara?
So when I had asked Mr. McKane about the relationship with the mother of his son, it was under the heading of "Tell me about your relationships," right? And he described a volatile relationship with her, and he also talked with me about the 2012 arrest and conviction on domestic violence charges. He brought that up himself.
You said he brought that up himself?
Yes.
What was Mr. McKane's demeanor like when he spoke about those issues?
So specifically with respect to the 2012 domestic violence incident, he expressed remorse that he acknowledged during his discussion with me that he had laid hands on a woman, but that he hadn't done that before and wasn't proud of that action. And one of the things that struck me about Mr. McKane's discussion, not only of the domestic violence incident, but the drug conviction in Concho Valley, as well as the juvenile conviction, was I didn't ask him specifically about any of those events. He provided them to me spontaneously. So that stood out to me because oftentimes folks who are facing significant legal charges won't talk about previous convictions or previous misdeeds. And he didn't know what I had already reviewed. I had informed him that my review had been limited, right, by court order. But he spontaneously brought up the juvenile offense, the circumstances around the Concho Valley incident and the subsequent violation of probation, having to go into a residential treatment facility because he violated probation. And then he spontaneously told me about the 2012 domestic violence incident.
Did Mr. McKane have any reason to not disclose that or trust to share that information with you?
Well, I can't speak specifically for what Mr. McKane's motivations would have been, but in general, it's been my experience that individuals who are facing criminal charges and are pre-trials particularly, right, they haven't been convicted of anything, are somewhat reticent to discuss previous convictions.
In speaking to Mr. McKane about his criminal history, did he blame others for his actions or things that happened in his life?
In general, no.
Did you find Mr. McKane presented an overly rosy or positive view of himself?
No.
Were there things in Mr. McKane's life he was admittedly not proud of?
Yes.
You mentioned that he self-disclosed these things before you brought them up. Did you find that to be because he was proud of them or acknowledging of them?
No, he didn't talk about these incidents in a prideful way. Sometimes evaluees will do that. They'll want to convince you that they're powerful or that they've influenced others, and they'll talk about their prior misdeeds almost as a badge of honor. And Mr. McKane didn't do that.
Dr. Fabian, when you're asking a person about their experiences, is it important to try and strip away your own experiences and expectations in your own culture?
Yes.
Why?
So you want to make certain that you don't bring preconceived notions or preconceived ideas to assessments. And I think that all of us have a lens that we view the world through. And we, particularly in forensic work, but in mental health in general, the people I evaluate are often very different from me. Very different upbringings, very different lives. And I have to be careful to set aside what my personal feelings are about something when I'm speaking with someone about their life, so that my feelings about their actions or their family of origin doesn't shape my ultimate opinion.
Were there things that Mr. McKane was proud of in his life?
Absolutely, absolutely.
Is it your understanding understanding, Mr. McKane is the first person in his family to graduate high school.
And that was what he had told me.
Was that an achievement for him?
Yes.
Did he talk to you about going to Paul Quinn to play basketball for a little bit?
Yes.
Did Mr. McKane overly inflate his basketball abilities or present as grandiose when discussing them?
No.
Can you tell us more about that?
So, Mr. McKane was very matter of fact about his athletic prowess. His height and athletic abilities set him apart from others in his peer group, and he aspired to play professional basketball. And he told me about times when he attempted to try out for a semi-pro basketball league, but he wasn't chosen. Which I thought was interesting, because he acknowledged that he tried out, but he wasn't good enough. And when he talked about staying in school kind of long enough to make it into the NBA or to play basketball, he talked about going to play basketball at Paul Quinn, which is not a basketball power. So that didn't seem to be inflated or grandiose at all, but more realistic.
And is it fair to say that graduating high school and getting an opportunity to go to school at Paul Quinn, that those could be proud moments for him and his family?
Absolutely.
On his family, during your interview with Mr. McKane, did he talk about his family?
Yes.
What was his demeanor like when talking about his family?
He was very proud of his family. He was proud of his mother and the work that she had done, and he acknowledged that she was gone a great deal because of the jobs that she was working. But he was proud of her for the work ethic that she had. And he was proud of taking care of his siblings. And it was actually that discussion that led to his disclosure of the juvenile incident in 1999.
And I will definitely have some questions for you about that. For now, I want to ask, during your interview with Mr. McKane, did he talk about experiencing racism in his life?
He did.
Can you tell us about that?
He mentioned that some of his experiences in elementary school, middle school, had in part been shaped by racism, and that he had come into contact with people who were racist toward him and treated him differently based on his appearance or the color of his skin. He indicated that became less of an issue as he got to be older and had more athletic accomplishments.
The topic of racism, was it something he brought up on his own or you asked him about?
I had asked him about his experience with racism.
Were Mr. McKane's reports about racism he experienced believable to you?
They seemed valid to me, yes.
Did you have any reason to doubt that Mr. McKane experienced racism, or that he at least understood he experienced racism?
I had no reason to doubt that.
Can you describe Mr. McKane's demeanor when discussing the topic of racism?
Mr. McKane was very matter of fact about that. He discussed, being in elementary school and being different in middle school oftentimes. But he was very matter of fact about it.
Was it something he dwelled on or ranted about in your interview with him?
No, and in fact, I asked him specifically about his experiences with racism, and he had made a general statement about having some difficulty in school.
Did Mr. McKane's discussion of his experiences with racism seem proportionate to his experiences?
Yes, they did.
Did Mr. McKane ever talk about getting back or seeking revenge on society or any particular members of society for the racism he faced?
No.
Have you evaluated individuals with an axe to grind against law enforcement?
Yes.
In that experience, what does that typically look like?
So, in general, oftentimes folks who are facing criminal charges or have been involved with the legal system will blame others for their actions. And whether that's blaming law enforcement or blaming family members or blaming acquaintances or job situation, but folks will often what we call externalize or blame others for their difficulties or experiences.
In your evaluation, Mr. McKane, was he like that?
Not in general, no.
Just one moment, please, Your Honor. Thank you, Your Honor. Dr. Fabian, I want to talk just briefly about some of the materials the District Attorney's Office provided you when you were first involved in the case. Were some of in the materials provided, I believe you referenced that included some letters in the materials you received?
Yes.
At the time of your evaluation, Mr. McKane, had you reviewed those letters?
Yes.
And to be clear, are those letters between Mr. McKane and a man named John Davis?
Yes.
Did the content of those letters factor into your diagnostic impression of Mr. McKane?
There was nothing particularly clinically significant in those letters.
If you recall, what was your general impression of those letters?
Much of the letters were just back and forth. I think there was one anecdote, if you will, of police misconduct that had been raised by the person who Mr. McKane was corresponding with, not by him. But it was mostly current events and things of that nature.
And to be clear, have you had an opportunity to review those letters to refresh your recollection regarding the contents of those letters?
Yes.
I want to shift gears and talk about a personality disorder that has come up in this case a lot. Dr. Fabian, what is antisocial personality disorder?
So antisocial personality disorder is a psychiatric diagnosis made to describe an individual who has a chronic, persistent, maladaptive pattern of relating to other people or viewing the world. As I mentioned, one of the reasons you talk with someone is to get an idea about their perspective on the world or their world view. And individuals with antisocial personality disorder often lack remorse for their actions. They'll have a persistent pattern of violation of the rights of others, be impulsive, fail to fulfill obligations, things of that nature. And then an important diagnostic element with antisocial personality disorder, from a diagnostic standpoint, is that certain symptoms have to be present from a young age. So certain of those symptoms have to be present before the age of 15.
Is antisocial personality disorder also just colloquially called ASPD?
Yes.
I think you mentioned that there is specific criteria a person has to meet to be diagnosed with ASPD.
Yes.
Dr. Fabian, you mentioned that there is certain criteria regarding before the age of, was it 15 or 18 that you said?
So for antisocial personality disorder, there has to be certain behaviors that are present before the age of 15. Now, in general, diagnoses of personality disorders are not made before the age of 18 because people's personalities are evolving during that time.
What is conduct disorder?
So conduct disorder is a diagnosis of childhood. So it's a diagnosis made to someone less than the age of 18, and it describes a pattern of failure to follow rules or to violate the rights of others. There are certain domains within conduct disorder.
Does there have to be evidence of conduct disorder to diagnose antisocial personality disorder?
Yes.
You mentioned that there's certain domains associated with conduct disorder. What are those domains?
There are 4 general domains within the diagnosis of conduct disorder. The first is aggression toward persons or animals. So picking fights, torturing pets, forcing individuals into sexual activity, things of that nature. Then the next domain would be deceitfulness or lying. So conning people out of things, stealing. Another domain would be destruction of property. So either setting fires or just tearing things up. Then the 4th domain is violation of serious rules. Things like, running away from home and staying out overnight, or skipping school before the age of 13, staying out past curfew or past parental rules when they need to be home, again, before age 13.
And you talked kind of about generally ASPD. Can you talk a little bit more about the criteria you're looking for to properly diagnose ASPD?
So for antisocial personality disorder, it's unique amongst the personality disorders that they need to bring a diagnosis from childhood. So there has to be evidence of conduct disorder symptoms before the age of 15. And then if that threshold is met, then you look for evidence of persistent violations of the rights of others, failure to follow rules and norms, things of that nature.
What does it mean for something to have to be a pervasive pattern? What do you look for there?
So in general, for something to be a pattern, it has to happen more than once.
Why does the DSM require a pervasive pattern? That is, why isn't just 1 or maybe even 2 instances enough?
Because for a personality disorder, that's a disorder in someone's kind of view of the world, the way that they view themselves in the world. And it's present in multiple settings, as well as over multiple points in time.
When you say across settings, what do you mean by that?
So an individual's symptoms of a personality disorder should show up in relationships, at work, at school, in a variety of settings, not just one area. For instance, not just problems with romantic partners, for example, or not just problems in school, but it should show up in multiple areas because individuals take their personality with them.
Is every bad act or behavior by someone an indicator of antisocial personality disorder?
No.
Why not?
So, again, isolated bad acts or antisocial acts do not a disorder make. The context is important.
The context of the act itself is important?
Yes.
In your practice, do you have experience evaluating individuals with antisocial personality disorder?
Yes.
Can you tell us what antisocial personality disorder looks like clinically? How do those conversations go with the person you're evaluating? What does it look like?
So most of my interactions with individuals who have antisocial personality disorder occur in jails. Part of my work through West Texas Centers is to provide jail-based mental health services. So I see folks who are in our county jails who have mental health issues or often behavioral issues that folks are concerned may be due to mental health problems. So I'll evaluate individuals in the jail setting. And typically, folks who have antisocial personality disorder will present themselves in a very positive light. They'll minimize the impact of their actions. They'll attribute their behaviors to other people. We mentioned externalizing and blaming others for behavior. And they won't take responsibility for, oftentimes, why they're in jail or why they're post-conviction.
Dr. Fabian, did you diagnose Mr. McKane with antisocial personality disorder?
No.
Can you tell us how you reached that opinion?
So I didn't believe that Mr. McKane met diagnostic criteria for having a conduct disorder. He had mentioned an incident in 1999 where he had brandished a knife against a family member in the context of a dispute in the home. But that was an isolated act. And in order to have a diagnosis of conduct disorder, you have to have at least 3 of 15 separate criteria that are present more than once. So a persistent, recurrent pattern of behaviors. And I didn't believe that Mr. McKane met criteria for conduct disorder.
How about the other domains?
So
Past that?
with respect to antisocial personality disorder, it's also important to know, again, the context of the behaviors. So antisocial behaviors that occur in the context of substance use, for example, are better seen as a manifestation of a substance abuse diagnosis and not of an inherent characterologic issue, as you would see with a personality disorder.
We mentioned earlier that you also received additional collateral information from our office, including statements from individuals in Mr. McKane's life and jail records and prison records. Did that information support your finding that Mr. McKane does not have antisocial personality disorder?
Yes.
Can you talk a little bit about that?
So when I was contacted by your office, I was provided information that I didn't have at the time of my initial evaluation. So I took a look at that information, much of which were collateral sources of information from family members, peers, ex-girlfriends, teachers, an array of people. And in reviewing that information, there was no evidence that Mr. McKane had been exploitative or bullying or taken advantage of individuals in those relationship contexts. Also, I had school records that included disciplinary and attendance records. And in those school records, I think over maybe a 4 or 5 year period, there were 35 or so referrals for disciplinary problems, but they were relatively low in magnitude. And what I was looking for were things like bullying or fighting, and there was one disciplinary record out of those 34 or 35 that referenced play fighting, which seemed maybe more like horseplay than maybe true fighting or predatory action. And then there were multiple disciplinary infractions for things like dress code violations, and not tucking your shirt in, not wearing a belt. And there was only one notation for skipping school. I think Mr. McKane had been disciplined in school for skipping 6th, 7th, and 8th period.
So for conduct disorder, you're really looking for multiple violations of truancy or skipping school.
Yes.
And for conduct disorder, you're looking for serious violations of rules.
Yes.
Does not having a belt count as a serious violation?
Not in my opinion.
I want to talk a little bit more about the juvenile incident and that incident. Did you have an opportunity to review